Okay, we're back with session 3, UK Brexit trade negotiations and the WTO. This is our third session. We've had 2 sessions so far. The first session on UK Brexit trade negotiations within the European Union. The second session on UK trade negotiations with countries outside the European Union and the UK's status with respect to EU FTAs. So the third session is the fundamental question about UK's status within the WTO. And so post-Brexit, what will be the UK status within the WTO and other major trade agreements? And how will corporations with major UK investments respond to all of the uncertainty associated with UK trade status? So for the third session, we have Meredith Crowley from Cambridge, Jennifer Hillman from Georgetown, and Laurent Bartels from Cambridge as well. So welcome to the University of Notre Dame here in London. And I think the order is going to be Laurent and then Jennifer and Meredith. So Laurent, do you want to start?
Yeah, thanks very much. And it's nice to be here and nice to be able to speak on such an interesting topic. And I might add, nice to have so many people in this country interested in trade law, because I've been here for a little while now, and one of the less good things about this country has been that I've been talking to myself, essentially, apart from occasionally Meredith, and about 3 or 4 other people. And now, like an ugly duckling, and my wife said, yes, but you've turned into a vulture. Anyway, so what's the position of this country in the WTO? From what you've been listening to and thinking about over the course of this afternoon, you will know that this is the cliff situation. Presumably that word has been mentioned. Whether we're at the bottom of the cliff or at the top of the cliff looking down, I don't know. And you probably have also heard a few views on how likely it is that we will be in a WTO only regulated situation in this country. For what it's worth, I think that is highly likely. I don't know if others have had different views, but I think that the political dimension of the EU for EU member states, and in particular and most importantly for Germany, is paramount. And I think that their interest in negotiating anything with the UK is minimal. So, as I was saying before, you've got probably about 27 different ways of saying immigration and or free movement. And I suspect that a large part of the negotiations will be that concept. So, that makes this part of the program important, because this is what I think is likely to happen. The UK on Brexit Day will be a WTO member, and only a WTO member, and I doubt very much that there'll be a trade arrangement, even a transitional arrangement at that point. I mean, never say never, but this is what I would predict. Of course, we know that predictions don't work these days, so I'm in safe company there. But what does that mean? Well, before the referendum, you may remember reading, if you were around, the WTO Director General, Roberto Azevedo, saying very publicly to a number of the major newspapers in this country, so this is sort of mid-June, early June, things are not going to be good for the UK when, if, that is to say, the referendum goes in this direction, which has happened, because the UK, well, it will be a WTO member, he said, which is an important point, because some people even doubt that, but no. The UK will be a WTO member, but it will be a WTO member without any specific schedules of concessions in GATT and commitments, as they're called, in GATT. And further to that, he said this will mean that the UK will need to negotiate with all other 160-odd members in order to establish its position in the WTO, and that, by implication, means that the UK is in a weak position. and therefore, kind and honest and intelligent people of the United Kingdom, please don't vote for Brexit. And then turns aside and says, was that okay, David? Well, I think that's complete rubbish, legally speaking. Whether or not the Director General of the WTO should have said something like that is another question, and we can all have our opinion on that. But I think that legally speaking, that's absolute rubbish. And so I got interested in expanding on what I thought was my instinct. And I was pleased to discover, after having a bit of a look at this over the summer, that I think the more detailed analysis supports my initial instinct, which is that the UK is not only a WTO member, but it is a WTO member with rights and obligations, both horizontal in terms of all the cross-cutting stuff, or the non-discrimination, or the agreements that anyone who studied trade law will not be able to rattle off because there are too many of them, except for Simon, Jennifer, and Rod. I mean, everybody apart from me. There's so many. But more particularly, these unilateral and then agreed and then having treaty status, but they are unilateral in the sense that they are the product of offers and acceptances. They begin unilaterally anyway, let's say, schedules of concessions and commitments. So the way that this works is, well, let me lay out the problem first of all. The problem, which is what people focus on, including the Director General, is that at the moment, the goods schedule doesn't say anything about the UK. It says EU on the top, European Union, and the words United Kingdom aren't anywhere. And with the services schedule, well, it's a little bit different because there the schedule is basically a long document. At the top says European Union and its member states, and I can't remember whether it actually lists all of them, but it doesn't matter, they're there. So that itself is a different situation. But let's just focus on the goods one. Most people look at that and they say, well, the words are missing and we know about contracts and, well, I don't because I was a terrible student, I can't remember, but there is something about privity, which is essentially, I think, if your name's not on the contract, it doesn't apply to you. Is that right? Something along those lines. And so people look at this and they say, well, it's a bit like that. The UK's name isn't anywhere, and maybe it's there, but only as the UK's there as a member state of the EU, and so when it stops being a member state of the EU, then it stops having these obligations. And of course, as you would have heard in the second session, this is most likely the situation with the free trade agreements, but it's different in the WTO. How is it different? Well, first of all, as the Director General rightly said, the UK is a member, so an independent member, and not a member as a member state of the European Union. So that already puts this in a different situation from what you would have heard is the situation with the free trade agreements. And what does this mean? In Article 11 of the WTO agreement, there are a number of conditions for being an original member of the WTO. One of these conditions is that you were a GATT contracting party, which the UK was from day one. Another condition is that you had a schedule of concessions and commitments under GATT and GATT's annexed for you. Or rather, to be completely control Y about it, a member for which schedules have been annexed. For which. So it's not necessary for you to annex these schedules yourself. It is possible for these to be annexed for you. And thirdly, having met these conditions, you need to have accepted the agreement in accordance with your domestic procedures. In other words, you ratify the agreement. So all of this is set out in Article 11, and clearly everybody thinks, and this happened, these conditions were all met in 1995. So what do we do about these schedules? They were annexed for the UK by the EU. I don't think this is particularly in dispute. The question now is, do these schedules now continue to bind the UK, or in fact, today, do they bind the UK, or something else? I think if you read the way that schedules are annexed to the GATT and the GATTs, and the small parenthesis, they're actually not. They're deemed to be annexed to the GATT and the GATTs by the Marrakesh Protocol. They're not actually annexed to the GATT and the GATTs. But same thing. If you read the way that works, it's fairly clear that these schedules are the UK schedules. If you look at the Marrakesh Protocol, which is the instrument that does this legwork, it says in paragraph 1 that a schedule relating to, or rather a schedule annexed for a member relates to that member. Words to that effect. Relates to that member, what does that mean? Well, those words come directly from Article 2 of the GATT and GATS, which is significant because that, Article 2, if I limit myself to that, is the article which establishes the obligation not to impose more customs duties than is set out in your schedule. Relating to is the key for that provision. So according to all of this, I think it's fairly clear, I can't see any counter-argument, that the schedule that has European Union as a title was annexed, or rather deemed annexed, to the GATT, and same for the GATTs, for the United Kingdom, and is the United Kingdom's schedule. So what do we do about the fact it doesn't say United Kingdom anywhere? Well, here I think the answer is that one needs to remember one's international law. And for that matter, probably other legal systems have something similar. And there is a basic distinction between the legal position and who has the right to exercise, or rather act, on the basis of that legal position. So, to put it in international law terms, you can have rights and obligations under a treaty, but that doesn't mean that you are the one that exercises the rights, and that doesn't mean that you are the one that performs the obligations, or rather, the one that is responsible, in this sense, for performing those obligations. That usually goes by the name of attribution, anyone who's interested in articles on state responsibility. And this is the way I think it pans out in the WTO. The UK is an original member, has been an original member since 1995. And what happened in 1995 is that the European Union, which in EU terms, as you all know, exercises exclusive competence, it does now, but there it was a little bit shakier, but in goods at least it was clear, and goods is the easier example. European Union, everybody knew, was the only party that had the ability to submit a schedule that would relate to the UK because it had exclusive competence, and as a matter of domestic EU law, and therefore as a matter of domestic constitutional UK law, incorporating EU law in a way that we've now learnt about in that that court case. What this means is that if you look at this from the point of view of the rights and obligations, the UK has all these rights and obligations. It has these schedules as its own. But if you look at who gets to run the rights and who has to stand in for the obligations, who is there in court when that happens, in both cases, that's the EU. That's what competence means. Competence is activity. It's autonomy in a positive sense, and it is accepting attribution for acts in a negative sense, in the sense of being a respondent. That doesn't change the underlying rights and obligations, and it's a conflation of rights and obligations on the one hand, and autonomy, the exercise of the rights, and performance of the obligations on the other hand, that I think has led to this confusion. So what will happen with Brexit is really pretty straightforward. The rights and obligations have always been there. It is the power to exercise those rights that is repatriated to the UK, and it is the responsibility in terms of attribution of acts to the EU at the moment. That will also change, and these acts will now be solely attributable to the UK. In other words, it will act for itself instead of having another entity act for it. An analogy might help clarify this. No, maybe that's clear enough as it is. I won't get in. I was going to make colonial analogies, but I sound a bit too much like Nigel Farage. But he's not altogether wrong. It's just that the UK became a colony, legally speaking, voluntarily. Now, what do we do, and now undid it, what do we do about the schedules? Well, here I've got a couple of things to say. I haven't been kicked under the table yet, so... So there are some aspects that are simple and some aspects that are not so simple. I don't want to say too much about GATS. GATS has a really particular point of complexity, but generally speaking, I'd say GATS just applies to the UK, and there are carve-outs which have UK written there, and that's all and limitations and commitment, blah, blah, blah. I don't think that's particularly difficult to work out what's going on. With GATT, it's a little bit more complicated for a couple of reasons, and GATT shares one of these reasons as well, but I'll illustrate it by reference to GATT. So in GATT, you've got a few different types of commitments. One is the famous 10% duty on cars, right? So that's called an MFN duty because the UK, well, let's say the EU has this in the tariff schedule, and the UK also does, I would say, as a matter of its obligations. And on today, the UK has its own obligation, which is exercised by the EU, technically, even more complicated, exercised by the EU acting as an agent of the EU, which has the competence to act for the UK. So it goes up and down a little bit. Regardless of all that, the UK has to impose a tariff of no more than 10% on cars, right? And on Brexit Day, it's going to be the same. So you might think, well, that's easy. Who's going to complain about that? Well, there will be complaints about that. Why? Because let's not talk so much about the cars, but let's imagine there's a similar sort of duty on car parts that go into the cars. And let's imagine, for argument's sake, that it's Japan that has been selling these car parts into the UK. Maybe there's no duty on car, maybe there is. Regardless, Japan is unhappy now because these car parts are going to a factory somewhere in the UK, Sunderland, let's call it, and the cars are being made there. And let's imagine, for argument's sake, that whatever the government has told Nissan in Sunderland can't actually happen because it's illegal. Let's just imagine that hypothesis. Honestly, cannot imagine what could have been said that's either effective in any serious sense other than speculative or illegal. So let's assume that what actually happens is that the cars don't get sold in the EU anymore, which means that the car parts market in the UK dries up. And that's clearly bad for the car parts manufacturers. Now, a lot of people get this confused with transit, which is a non-issue because transit's duty-free and there are special obligations for that anyway. So it's really about the downstream market and other aspects to competitions. But in this particular constellation, what we're interested in is the drying up of the downstream market for cars, and that is very bad for car parts exports to the UK. And for car parts, you can think of, I don't know, banks or any service provider or manufacturer that is an upstream operator of product services, which only sells in the UK because of downstream services and product going into the EU. And they are upset. Of course they're upset, but they don't necessarily have a right to complain. Why? Because WTO law is very clear on what the benefits of concessions, which is the mercantilist language used for obligations not to impose more tariffs than you promised, what these benefits are. And in fact, other benefits under the agreement. What are the benefits that are guaranteed? Why can Japan not complain that its car parts have lost a market in the UK, which is what the complaint is? And with global supply chains and so on, it's a big complaint, and they are going to get screwed. But that doesn't mean they've got a legal right to complain. The benefits that are protected are that your expected access into a market is protected, and that's essentially that you won't get more tariffs imposed on you than before. And that when you get into that market, you won't be discriminated against. And that's fine because car parts from everywhere and in the UK are in the same awful situation. I mean, they're going to die if all of this happens. But what is not guaranteed is that there will be a market. Market can dry up, market can disappear. Perfectly straight, could do any reason. No, because the government decides it's public policy or whatever. So long as it's non-discriminatory, it can do whatever it likes to a market. Everybody knows that. But there's also case law on this precise point. Banana's case. In Banana's case, those of you who know WTO law will be familiar with its many wonderful phases, but this is in one of its last phases, thank God. And what happened here was that the United States was able to bring a case involving Ecuadorian bananas against the EU. Why? On the spurious assumption that one day maybe again Hawaii will make some more bananas or something, but it doesn't really matter. With all due respect to those who know things.
We service those bananas. We make sure they're ripe and they're graded and they're properly marked and they're inspected and they don't have bugs on them and all that. Yes, that happens in the United States before they're shipped here.
Now the Americans knew the Americans knew full well, because this was obvious, that these were Ecuadorian bananas, right? And it also meant quite clearly that they were going to get no win out of the case, no real win out of the case, because you can only retaliate to the extent you've lost trade, and Ecuador could do this, but not America, because they were not American bananas. So in order to try and claw something out of this case, Americans tried this one on. They said, our problem is that we have lost our business, our market access for fertilizer, which we ship from America to Ecuador in order to grow these bananas with. Now, for fertilizer, you can read car parts. For bananas, you can read cars. And it was very clear. The arbitrator took about 5 seconds to say, don't be ridiculous. That sort of thing is not protected. So it seems to me that that particular complaint goes nowhere. And where you will hear this is when third countries say, and they say this quite a bit in Geneva these days, they say, oh, but we thought that we were getting access to a single market, and now we're not, and it's tiny and, cold and wet, and it's not what we wanted, and now you have got all this market access to us, which we shouldn't have really given you because we thought we were going to get so much more. And the answer is, I think, legally fairly clear. It's not just this case, a whole lot of them talking about benefits under the agreement. They all say the same thing. Just suck it up. That's the way the cookie crumbles. Bad luck. Some things happen and they're not legally protected. Not every grievance is legally protected, and this happens to be one of them. There are some other details that do need to be ironed out, and those details, and the final thing I'll say, are to do with commitments that you see in Schedule of Concessions, which can't easily just be copied and pasted into another document with the United Kingdom at the top. And that is because they are described in terms of a quantity of stuff, like money, and that quantity needs to be divided up somehow. And there are two of these quantity problems. One of them is to do with the right to dump money on your farmers. And that quantity at the moment is there for the EU 28. No one ever thought that this would have to be divided up. And the other quantified obligation is the obligation to allow in a certain amount of products, again, agriculture, at a lower duty rate than beyond that quota. These are called tariff rate quotas, and for some reason, and I'm sure Jennifer can explain, these are not seen as quotas, but they're pretended to be tariffs. Now, how do you divide up the quotas, and how do you divide up the right to subsidise? Well, the first thing I want to say about this is that some people take the fact that this will need to be done, and that there is no express rule in WTO law for doing this because nobody envisaged this situation, as proof that the schedules can't be UK schedules, because we don't know what they mean. Well, that sounds like the sort of approach that a lawyer should not like, because law is predicated on the assumption that it represents a complete system, which means in practice that if there's no principle written down, you just make one up. And there are plenty of ways of making them up. You make it up by referring to equity. That's what the International Court of Justice would do, flick a coin or something like that. Anyway, there are various ways, and WTO law gives you plenty of hints as to what you might do. You look at historical trade over the last 3 years, you make sure third parties aren't harmed, this and that. It can be done. In terms of the tariff rate quotas, and in terms of the agriculture, well, depending on how far and wide you want to range, there are ways of dividing up shared rights. It happens every time a country disintegrates. It happened with Yugoslavia, happened with the USSR, happens to Czechoslovakia. This happens all the time. There are rules out there in international law. They're not great. They differ from case to case. Let's call them guidelines. It doesn't matter. If this came to dispute settlement, it could be done. So, what should then happen? Well, I think in practice, what should happen is that the UK, on Brexit Day, should go to the WTO and should submit a piece of paper with the word United Kingdom on the top, and it should have a list of all of its commitments, which are at the moment in a document with EU on the top, but they're going to be the same, and that will now be the UK schedule, and it should assert a view of its obligations and rights, which are actually just the flip side of commitments not to subsidise. That's why you find them in the same document. On these two quantified elements that I mentioned. Now, what will happen if the others don't like this? I agree. I don't think the others will like this. Why would you? I mean, if you can object, you're going to object. I mean, that's why you're a diplomat, right? That's your job, is to raise your flag. So we can expect objections. I don't imagine it's going to be smooth sailing. But so what? Well, what happens when there's an objection to this sort of assertion is that you trigger a process of negotiation to make sure that third countries are not in a worse position after you have, it is alleged, modified your schedule. Now, I don't even think this necessarily is a modification. I think you can see this as what's called a rectification, which is simply correcting a few details, but let's assume it's a modification. What happens then? You haggle over how much worse off these third countries are. And so long as the UK makes sure that they're not actually worse off, which is not really all that difficult, let's face it, because they're not going to be worse off than the situation now. There's no need for them to be worse off than the situation now. This can be done. Then all these negotiations are going to lead to a big fat zero for the other side because they've got nothing to complain about. Of course, that's not going to stop them complaining. They're going to pretend that they're worse off and so on. So what happens if they think that they're worse off? Well, Article 28 is fairly clear. If they think they're worse off, then they get to, and there's no agreement on this, then they get to, let's call it retaliate. Shorthand, it's not called, it's got friendlier language, but essentially it's retaliate. What happens then? Well, the UK might not like this, and that's when the UK brings a case. The UK brings a case and says your retaliation is too high. In fact, you don't get to retaliate at all because you've lost nothing. And that case can happen, and that case has happened. Happened back in good old GATT days, cases called Canada Zinc. And the result was that Canada, which had retaliated under Article 28, had retaliated by too much. It was able to retaliate a bit in that case, under 28, but too much. And so the country that had modified, which was the EC, essentially walked away fairly happy. So that scenario doesn't strike me as particularly terrifying, nor does the opposite scenario, which is that the others say to the UK, somehow you have violated your obligations under WTO law, so we're going to bring a case against you with the TRQs or the subsidy rights or something. What does that mean? The UK doesn't have to negotiate, it gets the panel to do all the dirty work for it for free, which is wonderful. So I don't see that as a particularly horrible situation either. Fundamental point is this. If you accept the assumption that the UK has schedules, and I cannot see how anybody can read through the Marrakesh Protocol without coming to this conclusion, and Article 2, there's a point there about whether the EU might be responsible for compliance with Article 2, but nobody has said that, and there are reasons why that's wrong, or at least undesirable. It has to be the UK responsible for its own schedules. If you accept all of that, then all we are talking about is a question of interpretation. And questions of interpretation are dealt with, even difficult ones, by courts every single day. None of that should hold any fears for the UK. And then one very final quick point. What if I'm wrong? What if I'm wrong and the UK has no schedules? Well, that doesn't strike me as particularly bad for the UK either. Because in that situation, it's got all the rights and none of the obligations, or at least none of these. Now, a lot of people, including some eminent Geneva lawyers that I'm mystified to hear this from, think that there is an obligation in WTO law to have schedules. Now, there is actually in the GATS. There's an obligation in the GATS to have a GATS schedule, which just demonstrates the point that the UK must have a schedule, because otherwise it would have violated GATS and also wouldn't have met the requirement of Article 11 of the WTO agreement to be an original member. But what about the GATT? Well, Article 2, contrary to a very popular misconception, doesn't say anything about having to have a schedule. It just says that if you have one, you have to comply with it, not go over it. It's like a system of contract law. You don't have to have a contract, but if you do, you've got to stick to it. It doesn't tell you that you must have one. That's a very common misconception, and that's, I think, what the good Director General had in mind when he was talking about the UK, first of all, not having a schedule, which I think is a misreading of the Marrakesh Protocol. Secondly, that as a result, the UK would have to negotiate one, and I think that is a very basic misreading of Article 2. Put that together, and I think you end up in a situation which is that there are some interpretive questions out there, but they can be solved, must be solved, more to the point, which means they can be solved. And none of the different procedural routes which might have to be followed for these interpretations to be figured out are bad for the UK. In fact, they're all good. Thanks.
Okay, a lot to unpack there. So I have a question right off the bat about the United Kingdom's basically applying the European Union schedule as if it's its own following Brexit. What will be the UK tariff rate that it should apply with respect to the European Union products? Is it going to be zero tariffs, or is it going to be the WTO schedule that the European Union had for external countries?
Oh, well, the EU is just another third country. So, I mean, it has to be the third country MFN rate. Otherwise you'd have a violation of MFN anyway, in the absence of an FTA, sure.
So under the new arrangement, all of the current tariff rates that the EU applies for other countries will now be the tariff rates that apply between the European Union and the United Kingdom.
Yeah, on both sides they'll be applying equal tariff rates to each other. Now, of course, the UK can drop its tariff, as can the EU, although it's highly unlikely. UK can do that if it wants, but then it loses.
The bound rate is what?
Yeah, this is the bound rate. Yeah. Right. So it can drop and it can negotiate higher. I think that would be overcomplicating the matter on Brexit Day, but it could go higher. There's a lot of precedent for instance, on this point in the practice of the newly independent ex-colonial countries in from 1950 actually. Indonesia was the first one, right up until 1997. There was a bit of fancy footwork to keep this going after the WTO came into effect because they were a bit slow off the mark. But half of the WTO membership, there's 64 countries, 64 new contracting parties. When they became independent, copied and pasted the schedule of their former colonial masters as this schedule applied to their territory into a new piece of paper with their name on the top. That was the practice. Not, interestingly, written down in the GATT anywhere, which makes it more powerful. That was the practice. So it has been done before.
Sure. I mean, I had decided that for purposes of today, at least, that I would assume that we've all accepted everything that you've just heard, so that the, quote, easy part of the UK withdrawing in terms of its WTO, Brexiting in terms of its WTO relationships was everything connected to the schedules, meaning all of this, what is the tariff? The GATT schedule was going to be easy for all the reasons that Laurent has just said. It's going to be easy to just cut and paste the EU schedule and have it apply to the UK. And similarly for the schedule governing the General Agreement on Trade and Services, the GATT schedule, same thing, cut and paste and apply it. And so on day one of Brexit, we're all good on both goods and services. So I thought I'd touch on a couple of the areas where I think there are going to be a lot of problems on day one of Brexit, where at least the UK and potentially both the UK and the European Union, minus the UK, must do something. And the couple of ones that I wanted to touch on are the area, first of all, of trade remedies. And so for those of you that are maybe not in the trade world, these would be both anti-dumping duties and so-called countervailing duties that are applied on goods. So just to give you a sense of where things lie right now, the European Union has 142 anti-dumping measures in place today. It has 15 countervailing duties in place today. So what's an anti-dumping duty? An anti-dumping duty is a duty that's applied if imports come into the European Union that are sold for a price that's less than what they sold for in their home market. That's considered dumping. I mean, the idea is you can't sell at home for $100 and turn around and sell on the cheap for $50 in the European Union, or you're dumping that $50 cheap item, and therefore you have to pay a duty of $50 to make up the difference between the export price, $50 coming into the EU, versus the $100 that you're charging at home. All right? So, on
an individual product, right?
On an individual product, so it's on a product basis, product-specific basis, company-specific basis, country-specific basis. So the margin of dumping might be different depending on who's the home market. because the price, I'm making it up, of $100, maybe that's the price in Indonesia. If the price in Malaysia is 80, the dumping duty on Malaysia is only going to be $30 because it's less dumped, if you will. But again, for what it's worth, right now in the European Union, dumping duties have become extremely important to a number of very politically sensitive industries. Why? Because of China. So out of this 142 anti-dumping duties, 55 of them are on China. Because in the last number of years, China has, among other things, added, for example, 60 million tons of steel production every single year for 10 years in a row. That 60 million tons, just to put it in context, is more than the entire US production in the United States. It's just additive of capacity within Europe. Within China. So China is now by far, far, far the largest producer of steel. It's becoming the largest producer of aluminum. It's among the largest producers of most chemicals. It's done the same thing in raw materials. So over a host of products, China has gone from having slow or modest market share to being the dominant seller in most markets, and again, at fairly significantly dumped prices. So for many companies in the European Union, the existence of these dumping orders, even though Simon hates them, are very important to them, all right? So what's going to happen on day one of Brexit with these anti-dumping orders? All right, so you are required under the anti-dumping law. This is not under the anti-dumping agreement of the WTO. This is not one of these ones where you might have to. You are required to provide a notification to the WTO whenever you impose an anti-dumping measure. So all 142 of these notices read European Union. So they've all been notified on behalf of the European Union. So I think come day one of Brexit, they are no longer, in that sense, valid notices on behalf of the UK. And I at least am going to posit here for tonight, it's not clear to me that they're either valid on behalf of the European Union. Why? Because in order to apply an anti-dumping duty, you have to have a home market price minus an export price equals your dumping margin, all right? And you have to show that those dumped imports, those particular dumped imports, have caused injury to the domestic industry that's making the same product. Why? Because the presumption is if you're just engaging in dumping and it's not hurting anybody, nobody cares. I mean, whoopee, we get our steel for $50 instead of $100. You would actually want everything to be dumped if it was not causing injury to somebody that's also making steel. I mean, who is complaining about this $50 steel is the people that are having to compete with it, because they say, my cost of production is $90, and all of a sudden you got all this steel coming in from China at $50. I can't compete with $50 steel because it costs me $90 or $95 to make this ton of steel, so I want you to put a $50 anti-dumping duty on all of this steel that's coming in from China or wherever. All right, so the problem is the notifications are specific to the EU. Second problem is that the export price is the export price to the EU. So when they make an anti-dumping determination, how does the EU figure out what is the export price? It looks at the prices across all of the EU member states in which the steel is sold, and it creates a weighted average of all of those. So how many tons at how much euros, and it comes up with an average weighted price, and it subtracts that from the home market price, wherever it's coming in from, and it determines the margin on a union-wide basis. So my own supposition would be on day one of Brexit, all of those margins have to be thrown out because they were determined on a union-wide basis that no longer includes the UK.
I'm very happy that you're invalidating all of these orders.
I would argue that it invalidates them both on the EU side and on the UK side. The other part of it is that it requires you to show that there has been injury to the domestic industry union-wide. So again, what do the dumping administrators do? They look at the financials. What's the profits? What's the productivity levels? What's the employment levels? What's the wages? What's the capacity utilization, et cetera, et cetera? They add up a whole series of financial factors to figure out whether or not the domestic producers of steel are being injured by these dumped imports. And I will tell you, in many of them, I haven't read all 142, but in many, many of them I've gone through and looked, and quite specifically, they include UK companies. So what you cannot now do is say that I'm deciding that the European Union steel industry has been injured because of these imports. You would have to take out all of the injury to Tata Steel located in the UK. You would have to take out all of the injury to British Steel in the UK. You would have to take out all of the financials from the UK companies. And again, I don't mean to just pick steel. This is over a vast array of products from a large number of countries and companies where you're going to have to redetermine. Is the domestic industry, this would be the EU minus the UK, injured because of these imports in order to keep this anti-dumping duty on whatever these products are coming in? Then let's come over to the UK side of it. Let's say the UK producers, Tata Steel alone, says, I want a dumping duty here in the UK. Where are they going to file this anti-dumping investigation? Right now, there is no such thing as the equivalent of a trade department like there is in Brussels that can even hear the complaint. So there isn't anybody to file it with. There isn't anybody in the UK that's charged with calculating a dumping margin. There isn't anybody in the UK that's given the legal authority to investigate whether or not injury has occurred to the domestic industry. So there is nowhere to go to file these anti-dumping cases. So I think, again, on day one for Brexit, this issue, given how important of late these anti-dumping duties have been with this rise of China in particular, a significant issue. Subsidies, it's sort of the same story. In other words, when you have a product, in theory, the gist is that you cannot trade in a product if it's been given a government subsidy. A subsidy defined under the WTO agreement is a financial contribution that's been given by a government or a public body that confers a benefit on another producer and is specific in some way to that producer or industry. So again, let's assume, and I think it's a very safe assumption, that all of this steel coming in from China has been proven to have received very substantial subsidies from the Chinese government, all right? So the idea is, if 50% of the cost of producing the steel has been subsidized by the Chinese government, you can then put a countervailing duty on to offset that 50% of the cost that was paid for by the Chinese government in subsidies. You can put a 50% duty on the imports that are coming in to countervail against the subsidy. Again, 15 cases right now, 15 orders right now. You may not have the same issue with respect to the margin, but you clearly have the same issue of, can you prove that the domestic industry was injured by these subsidized imports? So you're going to have the same problem where you've now mixed the industry with UK producers and European producers, and you can no longer do that because the WTO agreements both on anti-dumping and on countervailing duties are very specific about who is the domestic market that you have to look at and who is the domestic industry that you have to look at it. And you would not be able to say that there is injury to the European market or to the UK market without looking at it very specifically according to all or nearly all of the producers in that market. So again, I think on that score, you're going to have huge issues on day one. The other one that I was going to just touch on very briefly, where I think there's going to have to be a lot of attention on day one, is the other place in which there have been very substantial number of notifications with that heading European Union on them, is on sanitary and phytosanitary measures. All right, so these are rules that say whether or not you can ban imports of beef because the cows that are in the country from which you're exporting it, maybe they've been treated with a little hormone clip on their ear, or maybe they're coming from a place that has foot and mouth disease, maybe they're coming from a place that has mad cow, whatever it may be. There is, in many instances, an EU-wide restriction that we will not accept imports of wheat from Canada because it has TCK smut, or apples from wherever because they have the apple leaf curling midge that grows in apple trees in New Zealand. You'll have these fights over these SPS measures, but if you look at them, there are hundreds of them that the European Union has notified that are creating European Union-wide bans, and these bans are required to be maintained with, as it says in the SPS agreement, sufficient science Oftentimes they have to be maintained because you've done a risk assessment of what's the risk that if we import apples from New Zealand that have apple leaf curling midge bugs connected to them, that those apple leaf curling midges will somehow proliferate throughout the European Union. You have to have scientific basis, you have to have a risk assessment, you have to be able to show that there's a reason why you are entitled to maintain a ban on whatever this product is from this other country. And again, many of them, not all of them, but many of them have been done Europe-wide and on the basis of both scientific evidence and risk assessments that have been performed by EU-wide institutions. So it is not at all clear that the UK can maintain any of those without doing its own risk assessment and without doing its own scientific analysis of it. And depending on what it is, it may be a little unclear whether the EU can keep all of theirs. I think there it's more likely than in the dumping world that the EU can keep their SPS measures, but it is not at all clear to me that the UK can maintain any of these bans. And I think some of the products are going to be viewed as very sensitive to all of a sudden now say, GMOs, bring them on, UK, I mean, et cetera. I mean, I think there's a lot of these products where there's going to be a huge sensitivity about whether or not you're now opening up the UK to trade in all of these products that have been banned for many years on SPS grounds. So I'm only flagging a couple of other, right out of the box, I think, at least, issues that are worthy of a little more thought and thinking about what is the UK going to have to do on day one if it wants to figure out a way to effectively cut and paste whatever the restrictions are that are being applied EU-wide and make them somehow remain applicable. If the UK wants to do that, I think at least in the anti-dumping, countervailing duty, and SPS area, at least for me, I think there's very significant problems about whether you can do that and what it will take for the UK in order to do it. And I think there's a lot of political sensitivities if the UK doesn't figure this out, where all of a sudden, day one of Brexit, in floods lots of Chinese steel that had been subject to these anti-dumping orders that's now coming in without paying dumping duties, maybe not so happy by a lot of people on the Brexit side. So I'm only flagging something different, I think, than what the normal schedules have been talked about. Anyway, just to
react on what you just said, it's there's an impact, immediate impact that you can see on the internal market, because as soon as goods enter the UK without protection, in particular for health and safety, or at low cost, it means that there are good reasons for the EU member states to block these goods at the border. So there are good reasons to.
There would definitely be borders. I mean, right? You were looking at me, so maybe you're thinking
no, because
about
you were saying, you were against all these.
Well, I'm against tariffs, but
he's against anti-dumping duties as well.
Right.
Yeah.
But as soon as these products enter the UK without any
But you could
control.
still have EU border measures, checking for health. I mean, the EU could still apply its SPS measures against products coming from the UK.
Yeah.
I do worry about the dumped product. I mean, there is going to be a concern about these products being dumped in the UK and then passed along to the EU, and the EU would be worried about sort of circumvention of its own anti-dumping duties. I don't know how to deal with that.
Yeah, but the thing is, there is this direct relationship between external trade and internal trade that you see will play in the negotiation within the EU, because...
So my assumption would be, in your scenario, that the day one after Brexit, the UK would continue to impose €50 duties on Chinese steel, and that the European Union would also continue to do €50 duties on Chinese steel. So assuming that that's what's happened, which is they're going to assume that we're just going to continue to apply these duties, so China obviously brings the case against the WTO and challenges the imposition of the duty as what?
A violation of the
tariff
anti-dumping
binding
agreement. No, as a violation of the
well,
anti-dumping.
either.
There was no injury test,
There's
so
no-
they
there's no
have no
proper injury
evidence.
test.
There's been no injury test.
But the only problem with
in
her
the
argument is, though, the injury test was based on a temporal limitation of this period in the past, right?
No, it's based on a geographic limitation.
But I thought it was a temporal limitation as well.
Well, arguably both, but in any event, the injury determination is the domestic industry producing the like product materially injured by reason of the dumped imports? So again, when you did that, you examined all of the producers, including the UK producers.
But don't they do periodic review? Is it annual reviews?
Yeah, well,
or?
Not of the injury.
No, the injury is reviewed every 5 years,
Yeah.
but not every
So
year.
wouldn't they just say, well, we'll do the periodic review in the appropriate
If
time?
I were
but in-
China, I would say no.
Right.
No. I mean,
The anti-dumping.
no. If I were China, I would file the case on day one. And say,
7% of Chinese imports are under anti-dumping orders. 7% of their
So they should
total
sue for
value
all
of
these- every
exports
single
to the
duty they should-
EU.
they should
That
sue.
is a huge.
If I were
it's
advising the
$100
Chinese
billion
government, that's what I'd
worth
tell them.
of goods.
challenge
Go
both
day
the
one.
EU and UK anti-dumping duties on all products.
Definitely.
Can I?
And
Yeah,
I
it's
mean,
amazing.
I think a challenge is going to come if nothing else, happens in the interim. Yeah.
Well, as lawyers, of course, we love challenges. A couple of follow-ups. One, a question really. With the anti-dumping duties, one of the problems is that word from Brussels is that if you read various provisions of the EU treaties in a particular way, it handcuffs the UK from thinking about the EU's common commercial policy, and those provisions are Article 433 of the Treaty on European Union, Article 3 on the Treaty of European Union, and Article 207 on the TFEU, which is the second treaty. Now, I actually don't think that's right at all. I think that's a complete misreading of those provisions and relevantly 433, which is sort of called loyalty, sincere loyalty. Why not make it sincere? I think it's a complete misreading of this in a Article 50 context. But leaving that aside, if that is correct, then the UK presumably is not only unable to negotiate free trade agreements, and I'm sure that this concept and problem has been spoken about already, but presumably would be prohibited from, assuming it had the administrative capacity, it would be prohibited from mounting an investigation of its own in advance of Brexit Day in order to establish its
because
own
of the exclusive
anti-dumping
competency of the
duties.
European Union on trade matters, they're not even allowed to look at this issue until they're out of the European Union.
Right. So one thing is, can you go off and chat to the Indians? I mean, let's face it, all of these different bits of the Treaty on the European Union, etc., don't seem to be stopping that trip today. Quite explicitly to talk about trade agreements. So,
I mean, my answer to that is that, okay, technically they're not allowed under the EU to engage in these sort of negotiations with any other trading partner, but okay, so sue us. I mean, we're going to talk to the Indians, we're going to talk to the Koreans. You're going to say it's a violation of the European Union. We're leaving you anyway, so we're going to negotiate with all these countries anyway. And what are you going to do if we do?
Well, there's a bit more to be said about that, I think. I mean, firstly, I think it's wrong. I don't think it's the right view. I don't think it's the right legal interpretation. Because it doesn't jeopardize. This is the phrase, Article 433.
It's wrong to
jeopardize
tell the UK
the
that they can't do these negotiations.
Doesn't jeopardize the attainment of an objective of the European Union to negotiate in advance for an agreement that only kicks in on Brexit Day. So it doesn't. I mean, I think it's just complete misreading. But more to the point, third countries have used this as a reason for not negotiating with the UK. And I'm sure this came up, unfortunately, when I wasn't here. It's the third countries that aren't interested. And Australia, my own country, has been citing its own analysis of all of these provisions as a reason for not negotiating with the UK. And I know for a fact, and you can speculate as to how I know this, that the Australian government knows, or at least should know, should remember, that that's not necessarily a correct interpretation of EU law, but it doesn't matter because it's a very convenient way of third countries, pushing it back. So anyway, this is one point which is made very difficult for the UK, according to EU law, as the EU starts talking about it. And that is relevant because the EU ultimately has the whip hand in a lot of this. So that's one problem. And so my question there is, how much time does an industry like Tata Steel have if the UK plays it legal according to all of these particular interpretations and waits for the legal ability to set up an anti-dumping administration, run a procedure and impose duties, how long would that take, and would that time be fatal to Tata Steel?
Well, personally, I think there's no reason why they can't set up their own investigating authority today. I mean, I see nothing in it that says that the UK can't start the process. And again, under the anti-dumping agreement and the subsidies and countervailing measures agreement, they do have to notify who is the competent authority. So on day one, my own sense is if I were the UK government, I would have an anti-dumping and a countervailing duty investigating authority set up. On day one, I would provide the notice under Article, it's 25, 11, and 12 of the SEM agreement, and I can't remember where exactly, 15, I want to say, in the anti-dumping agreement, where it says you will notify in advance who's the competent authority. So you should say right up front, here's our competent authority. How long does an investigation take? In the United States, it takes statutorily 435 days to complete a beginning, a prelim and a final dump or countervailing duty case. You could probably do it in a little less than that. My own view is I think they could even start the process. I mean, set up the institution now. When you think you're a year away from Brexit, begin your investigation. So you're collecting all the data and sending out the questionnaires and doing all of that stuff, but you wouldn't impose the actual anti-dumping duty until day one. But you could, in theory, could do it, I think, all in advance, because none of that I don't read as jeopardizing, because this is not entering, this is a unilateral measure. I mean, you have to remember, anti-dumping duties are not negotiated. I mean, it isn't as though you're actually talking to China other than saying, cough up your data. You're having no relationship with China. So in no way is this violating a kind of, a sort of prohibition on negotiating. I mean, these are total unilateral measures. So my sense is I don't see any reason why. I don't think the UK could actually impose an anti-dumping duty on its own. Do I think it could investigate whether anti-dumping is going on and figure out what the margin would be? Would they have their own authority? Yes.
Maybe they couldn't legally impose the duty, but could they just continue to impose the duty and then, while they're losing the case before the WTO, do all of this process?
You have some time before you're actually...
buy yourself
right. I mean,
18 months
you're just
or whatever.
buying yourself the
they need 18 months,
2 or
though.
3 years of litigation. Yes, just keep imposing it. China will challenge. You'll lose the challenge, but you use the interim period to set up your own system. Yeah, you could probably do that.
Now,
I don't think it's ideal, but yes, you could do that.
Other quick question, whether you agree with this, that on SPS, is it possible that the situation isn't quite as bad for the UK because you are allowed to rely on risk assessments conducted by others?
Correct.
So that's always been a little bit of a, hard to figure out what that really means in reality. But this could be your case study, no?
And it depends, to me, it would depend on the risk assessment and the product. I mean, so some of them are, and again, I hate to keep bringing up apples, but I happen to have sat on the appellate body for this apples case, so I know the apples really, really well. So just FYI.
Are they tasty?
Well, I mean, but this sort of helps answer your question. All right. So this was, for those of you that didn't follow this was like, an 80 or 90-year-old fight where Australia banned the imports of apples coming in from New Zealand. All right. New Zealand is a significant and substantial exporter of apples. Australia is a medium level, if not low level, producer of apples. All right, but Australia, island country, and they say, all right, so what's the problem? There's a bacteria, a fungus, and this bug called this apple leaf curling midge that are all on the trees in New Zealand. All right, so Australia has maintained this ban, never had any ability to challenge it. Along comes the SPS agreement, and now there's a binding agreement with binding dispute settlement. So they challenge this ban, and they say, look, you can't ban our apples because of this fungus, this bacteria, and this bug. And Australia says, oh, yes, we can. And New Zealand says, no, wait a minute. The fungus, the bacteria, and the bug live on trees, and what we are exporting are apples. All right, so you cannot put the ban on the apples because these three things are only on the trees. So the risk assessment, just to be clear though, the risk assessment, for example, is whether it is possible and how likely is it that the bug, even though it actually lives on a tree, could nonetheless travel on the apple and arrive in Australia and then make it to be a, breeding successful. So the risk assessment is to some degree fact specific. I mean, in this case, it turns out this bug only lives for 72 hours and then it dies. It can only fly for 60 meters, that's its maximum distance, and it can only breed on the spring leaf of an apple tree. So then the question is, how likely is there to be a male and a female traveling, if it can only live 72 hours and the boat takes so long to go from New Zealand to Australia, and then it's going to be unloaded at a dock in Australia, how likely is there to be a spring leaf of an apple tree within 60 meters of where the boat unloads? Okay, no, you laugh, but the risk assessment for that situation couldn't just be cut and pasted over here for the UK. So some risk assessments, yes, they could borrow them. If it's the apple leaf curling midge, not so much, so they would have to do a new, I know you're laughing, but I'm serious. So some risk assessments, yes, you can cut and paste. Others, no, you're gonna have to start all over again and do your own risk assessment about whether the apple leaf curling midge is or isn't gonna survive in the UK. I will tell you it's too cold for the apple leaf curling midge, but we'll go on.
Can I ask one more question before we go to Meredith? And that is, can you present to Laurent your argument about why the UK is a member of the FTA simply because it's in the Korea-EU FTA agreement? The UK is a official member in that agreement, and I was just wondering if his argument is also applicable.
I'm only arguing that other people have argued it. I will say I think the better point under treaty interpretation is that they're not, but it more comes from this or language, because, and I do think there is something significant to say that the EU has entered into all of these trade agreements. I mean, lots of them over all different kinds of things, but the big ones all have this language about how this is an agreement between the European Union or its member states, or the EU and its member states. And they say both of those. So the Canada agreement, the Korea agreement, the Mexico agreement, the a whole, I'm trying to think of the other ones that have this language, Colombia, Peru, Egypt, Algeria, Iraq and Kazakhstan have this language of what I'm calling the or and language. And it is then, therefore, I think, legally distinct from anything, and it has nothing to do with whether you were an original GATT member. So my sense is, I don't dispute at all that the UK is a member of the GATT on its own dime and a member of the WTO on its own dime. I think it's harder legally to figure out whether the UK could assert rights on its own, that it is a member of the CETA, the Canada Free Trade Agreement. It is a member of the Korea Free Trade Agreement because it says the EU or its member states, and it specifically lists them, and UK is specifically listed by name, or the EU and its member states, comma, with respect to their competency. So, I mean, it's clearly getting at their competency. Again, my own sense is...
So does your argument about the WTO also apply to all these FTAs where it specifically says the UK is a member of the Korea-EU FTA agreement?
No, I mean, I think Jennifer and I agree. The situations are entirely different because in the WTO, the UK is a member in its own right, even though because it was a bit hamstrung domestically, the EU was able to do something for it, meet one of its conditions. Whereas in the FTAs, the UK and all the other member states are only there insofar as they are member states of the EU. So once the UK is not a member state of the EU, it becomes defunct. There's a second line of attack or defense, depending on who you are, on the FTAs, I think, which is that if that's wrong, the result has to be a fundamental change of circumstance for the other side. In other words, they would just suspend or terminate the agreement.
If it's in their interest.
Well, look, most likely would either be in their interest or correspondingly in the EU's interest. I mean, either they're upset because they've lost a huge market in the UK, or they're very happy because they continue to have all this access into the EU, in which case the EU would be upset. So one way or another, someone's going to be upset.
I mean, if I were Korea, I'd continue to try to get free duty rights into the EU and then independently negotiated free duty deal with the UK.
Exactly, and that's the point at which the EU says, we did this on the basis of the UK being a member state, and so we think there's been a fundamental change of circumstance, for which we are not responsible, which is also important under Article 62. Although you could argue they were by allowing Article 50 in the first place. But.
Meredith.
Okay, so I want to start a little bit back in time and just say, how did we end up here? Okay, and so talking a little bit about economic policy, and so many have commented on how did we arrive at this Brexit thing. But one of the things I want to talk about in particular is sort of a failure of economic policy and economists to address what has become very important concerns for workers in high-income countries. They don't have very good jobs anymore. Their jobs don't pay very much. They feel like they're suffering from the forces of globalization, and governments didn't respond. Okay, so specifically, we can see over the last 15 years explosive growth of trade from China. Okay, and so Jennifer's already given a great set of statistics. 60 million tons of steel capacity per year for 10 years. We can look at all kinds of specific industries, but the growth of trade has been explosive. Okay, and so we hit in 2008 this Great Recession. And so the thing is, well, what did the Great Recession do for people, and what's been the discourse? Okay, well, so the first thing is, I just went through and did some review of the words whales, steel, and anti-dumping from The Guardian and the FT. So you can look at different papers, but if you look at what happened to the British steel, I pulled two articles. One was from this past March, and it said, the crisis in British steel has been 40 years in the making. So this was an article in The Guardian, and he says, globalization, cheap Chinese imports, EU legislation, and a government reluctant to help were the causes of this destructive loss of jobs in Wales, this industry that's imploding in the UK. And so in particular, when you read just the beginning of this article, the second paragraph, it says, in the decades immediately after the Second World War, government was able to protect their domestic steel industries through the use of high tariffs. Now they can't. And so this idea that what we got from trade agreements and what we've been celebrating as economists and trade lawyers is that for the last 50 years, we had certainty over tariffs. Tariffs were low. And we saw this as a great way in which we could get a more efficient allocation of resources. But now the way they're perceived by many people working in high-income countries is this low tariff environment and trade agreements. It's a set of horrible handcuffs we're bound to. They're gone from being, liberating to these horrible chains, and they're perceived very poorly, right? I mean, just the whole structure. Another article I had was David Cameron accused of failing UK steel after EU proposal rejected. And this was this past spring again. There was this controversy over an ongoing case involving Tata Steel and some other European steel producers at the Commission. And the UK stood out against the rest of Europe and said, we want to keep some current rules the Commission has that restrict how high we can anti-dumping duties can be. So these would be duties imposed on steel from China. The current procedure in the EU follows something called this lesser duty rule. The UK has supported this, which keeps the tariff on steel relatively low. In the European countries, the continental European countries wanted this eliminated. David Cameron was one of those saying, no, we don't want this. Okay, so in terms of the popular discontent, what you got in the press was your British industry is failing. Okay, we're subject to horrible forces of globalization, and the British government isn't doing anything about it. Now, I also have, from a paper published a couple of years ago, Chad Bown and I looked at the use of anti-dumping duties in recessions. And so we looked at it in all periods of time, and we went through and we estimated how the different factors that lead you to impose more anti-dumping duties. And so these are not specific to cases of like the individual features, this particular study, an individual case. It was just an observation which had been made by others before. More of these duties are imposed during recessions. And that is because these are the times when the industry's circumstance domestically is very weak, and it becomes very easy for the industry to satisfy the injury standards that Jennifer was talking about earlier. So if we go back and we look at what happened in the Great Recession, if we use a model estimated on previous recessions and try to forecast how much anti-dumping we should have seen in Europe in, I have here in my picture, 2009 Q3, Chad Bown and I estimated 250 individual anti-dumping duties at the HSO6 product level. So 1/10 of all HSO products or HSO6 products coming into Europe, we would have expected duties against that many, so against 10% of products, given the horrible depth of the recession. What we actually saw was very little in that particular period of time. Ultimately, during the Great Recession, like the peak, Europe only imposed 40 of these. So, just 20% of what the model predicts. So at the time we said, this is fantastic. After decades of telling policymakers that anti-dumping is a bad policy, it's harmful because it reduces economic efficiency, we've finally had this victory in that they're using self-restraint and they're not using trade policy to deal with the harm of a recession. Okay, but the flip side of that is actually, if we were underusing the policy, in a sense, we're undermining the trade agreement, because at the same time that we were not using trade policy to deal with the loss of employment from the recession, high-income countries weren't using really active domestic policy to sort of smooth us through the recession. So austerity didn't help workers out either. Okay, and so what we were left with was a bunch of workers who really didn't have anyone in government looking out for them. Okay, and who really have, by many outcomes, suffered real loss in terms of their well-being. Okay, so many workers are doing great in America and in Britain, but there's a big chunk who aren't doing so well. And so presumably those are the folks supporting Brexit and supporting other anti-globalization forces. Now, I bring up this low level of anti-dumping usage in particular because from the perspective of economists, both theoretically and empirically, this goes into some other past research, we view the functioning of trade agreements as this contingent contract that both parties have to perceive as mutually well-being enhancing. So that is, the reason why governments have tariffs in the first place is because they're trying to take advantage of their trading partners. If they're both doing this at the same time, they realize we can be better off if we both reduce our tariffs symmetrically. However, in this type of environment, we know that governments are subject to random fluctuations in imports. Okay, so there can be changes of various sorts. In that case, when you have an unexpected contingency, you have a temptation to cheat. And so the economist's view of the contract of the WTO is that safeguards anti-dumping countervailing duties are this flexibility provision that sustains the low tariffs we see on everything else. And so the idea is, well, maybe if what we saw in the previous 15 years was a relatively low usage of anti-dumping, maybe the problem is, and at the time I certainly thought we were using it too much, but now that we've seen these trade agreements and support for them deteriorating, maybe the problem is we don't have enough flexibility to deal with real economic shocks in the in this WTO agreement and other agreements. And maybe part of the problem is, whatever we call it, we need to give governments a little bit more flexibility over their trade policy. And so that's sort of, I think, where we came from and sort of how we got to Brexit. And I think it's important to know what possibly were some of the failings and maybe some of the rigidities with what we had before as we're going into this new world, because we don't necessarily want to repeat the same mistakes. And if one of the mistakes is we had too much rigidity and not enough flexibility, that's something to think about as Britain goes forward and tries to think about what to do next. So what are the risks going forward? So just a few briefly. So the first thing is, now I've just told you the things I don't like about too little anti-dumping. At the same time, I'll tell you I'm still looking at this question. One of the things I've got is actually anti-dumping is damaging not just for the two parties, so not just the, if I am China and I'm exporting to Europe, I'm not suffering only on my exports to China. As a Chinese firm facing a tariff in Europe, I don't simply lose sales in Europe. Actually, we see, if we look at Chinese exporters, they become reluctant to export everywhere. So when one country imposes anti-dumping, this uncertainty about tariffs on that particular good globally reduce entry by firms into other markets. And so we see this in China. The same applies to Britain. So if British exporters don't know, British firms don't know what tariffs they're going to face around the world, this is going to create a strong disincentive for them to engage in exporting. So the costs and the uncertainty, the non-tariff barriers of entering new markets are high. And this could be very damaging going forward. It's particularly damaging these high costs of exporting and the uncertainty for small and medium-sized enterprises, which have a harder time getting information about foreign markets. Obviously Britain's going to face this external tariff going to the U.S. if we have going to the EU if they have to go through a hard Brexit. I think we had a discussion earlier, but my view is it seems like the most likely outcome is that the Europeans will say free movement of people or nothing. They're going to stick by that, and then Britain is going to face tariffs on exporting to the EU, and I can't see how they're going to get around the WTO unless they finally give way and concede on the free movement of people. So that's a risk in terms of selling to Europe. We might think, well, maybe the Europeans would say we should reduce tariffs because we ourselves benefit from trade with Britain. Okay, and so maybe they say, okay, we could sacrifice free movement of people. They don't really have a strong incentive to lower their tariffs as the larger party to the agreement. Because they have the most to gain from high tariffs. So if the EU and Britain want to be engaged in a trade war, the EU has more market power relative to Britain. They can push prices down more than the British can in the other direction. And so their strong incentive as the EU is to keep the tariffs relatively high. They also have this strange incentive related to foreign direct investment by multinationals. So I have from the FT, the 17th of October, German car industry warns UK over Brexit. So head of a German automotive businessmen's association saying, if Britain goes through with Brexit, their production's all going to move to Eastern Europe. Okay. Now, so then we also have Theresa May meeting with the head of Nissan and saying, oh, no. So what the press report comes out, Nissan is going to be committed to staying in Sunderland and they will continue to produce cars here. It's hard to see how that can be happening without really strong financial inducement. So I'll just say research from the US in the 1980s looking at the Japanese response to anti-dumping duties imposed by the US between 1980 and 1990 showed that Japanese firms were more than happy to, in the face of a tariff in order to export to the US, they just moved their plant into the US. And so a few facts. So Blonigan and Feenstra told us a rise in the probability of trade protection of 5 to 10% led to a 30% increase in foreign direct investment. And this is back in the 1990s. I mean, this is much harder than making a jump from the UK to France. Between 1980 and 1990, there were 431 cases of anti-dumping policy. 18.6%, so I think it was like 80 cases, resulted in tariff jumping FDI within 3 years. So these were plants that faced a duty, the same company is moving within the United States within 3 years. And then there was also a paper by Belderbos looking specifically at electronic parts in the European community back in the 1990s. And at that time he was saying that an anti-dumping duty increased the probability of 5% of FDI in that electronic 20% to 70%. So a huge increase in the likelihood of moving when the European Union, or the old precursor to the European Union, put restrictions on electronic parts. Huge incentive for FDI to jump into the European Union. So this just leads to what I call Theresa May's Sunderland problem. To me, it seems intractable. We know multinational corporations respond to tariff changes by relocating production facilities. Now, how can you get them to stay? So you can try, I think, if you're an active government policymaker and you think, okay, I don't want the plant to leave, I want to do what I can to keep these producers within the UK, you can try directly subsidizing exports. You could say to Nissan, okay, well, if you have to pay a tariff to go to the European Union, we'll just pay it for you. Well, that's a violation of the WTO, strong one, countervailable duty in the European Union. You could try various types of wage subsidies, discounted electricity, regional adjustment. these are all illegal under the WTO, especially as they're being conceived of in the press, which is that these would be industry-specific agreements. I mean, you could try to do a wage subsidy for the entire economy, perhaps. But the European Union has every incentive then to countervail these British subsidies, because if any effort that the British government makes to try to retain this production with financial incentives, the higher the Europeans can raise their tariff on these same products, the more likely it is that the FDI will jump. And who doesn't want to have a multi-million-dollar car plant in their jurisdiction? You know, who doesn't want those high-wage jobs associated with autos moving into their place? So it's just, to me, when I read the newspaper and I see that Nissan has been given assurances from the UK government and they're willing to stay, I'm just bewildered. I can't figure out what they could possibly have said, because if they said they would offer financial incentives, it seems like Nissan should understand those are countervailable. So that leaves me with the other thing they could have said was, we're just going to cave on free movement of people at the end of the day and make sure that we stay within the common market. We really promise that. But that also seems incredible because of the I guess sort of concern that the British population has in wanting to pull out of these European institutions. So I'm perplexed by that. You know, what next? If any financial incentives to keep industry in Europe, seems they'll be countervailable. They'll be countervailed. This will just make Brexit worse, because instead of a 10% tariff on autos, we might face you know, 120% tariff on autos and the entire loss of the industry. It seems to me, you know, the other thing I get from the press is there's this perception that the British government is approaching negotiations with the idea that somehow the Europeans are going to be willing to maintain low tariffs or free trade against Britain because they make claims like, oh, it's going to be good for the Europeans, it's going to be mutually beneficial. And that doesn't acknowledge the asymmetry of what the relationship has become. As a much smaller market country now, relative to this, you know, almost 300 million people in Europe, Britain doesn't have, even though it's got a very dynamic economy, the realities of demand and supply elasticities are such that the European Union now has all the power, and they can raise tariffs and push down prices of export goods and force some of that tax burden onto the British producers. So they have every incentive to not to play hardball in any trade negotiations, I think. And yeah, so finally, just, you know, that's sort of standard optimal tariff theory that we teach undergraduates, and for which we now have empirical evidence that this is how governments engage in setting their trade policy. You know, and finally, just, you know, just restating what I said a minute ago, I think it's very likely that the Europeans, if they have any sense, will just say, if they want free movement, they can just say, okay, we're going to play hardball and we're going to keep these high tariffs and go ahead and try to subsidize. We'll be happy to welcome all these firms to Europe. And I'm actually very worried about the situation as I see it evolving, because I think it's potentially very, very damaging for Britain. And I think there's a sense here that it's not a great place for young people anymore. That, you know, young people are going to pay the price of this policy that we're embarking upon.
So just to be clear, to make sure, so if there's a 10% duty that's imposed on UK automakers into Europe, a countervailing duty could apply a 10% duty on top of that, so it's actually going to be a 20% duty. Would that be?
Could be
100%
much
duty.
higher. Depends what
how large
kinds
the
of
subsidy is.
subsidies
Depends on how
are.
big
How
the
large the
subsidy
subsidy
is.
is.
So
If they subsidize all of the production, the duty can be 100%.
So say and you might think, okay, well, so the way the WTO rules work, direct export subsidies, which was the first one I said, those are the terrible. But you could think, okay, we're going to be a little sneaky and try to come up with some way to subsidize that doesn't really look industry specific. Okay, but then if you do that, it's going to have to be a bigger program. So you could try to offer wage subsidies to lots of workers so that it wasn't just in one narrowly defined industry, and hope that by by a lack
But I
of
thought they got around this by regional subsidies instead of industry subsidies.
Well, so the
Go
regional
ahead, read
subsidy.
Boeing, and it'll tell you where you can draw.
you can do that.
Yeah, I mean,
So I think, but there's two things. One is the program, as they try to make it non-specific, or they could make the program more and more expensive and difficult for the government to sustain. Okay, so that's one thing. So they have to be committed to putting a lot of money in. So that's costly. And then after they put this money in, it could then be countervailed at the border. So that's where you could go from a 10% tariff to 20% tariff. Or if the subsidy is seen as really big and really specific, it could get even higher. So they could try, they try interest rate subsidies. This is one of the ones where they've tried to sneak through things where at one point in time, governments can typically borrow at lower rates than private entities. So one one hand, other hand trick that governments used to use was they would borrow money at their low preferred government interest rate, which has the full backing of the taxpayers, and they would then give the money at that rate to the company and say, oh, well, we're not really providing any financial benefit because the interest rate is just the interest rate we, as a sovereign nation, get on our bonds. But then, a lot of case law has said, well, actually the interest rate, the financial benefit should be the difference between what any private entity would get and the government rate. So there's many, I can imagine there could be many creative ways to try to subsidize and make it look indirect so that it couldn't be countervailable. But I think at the end of the day, anything
I think as a rule
come
of
up.
Yeah, we have
thumb
just a
with
few more minutes,
subsidies
so
is-
reactions, yeah.
Well, just as a rule of thumb, if it works, it's probably illegal.
Yeah.
well, yeah, so again, for those of you that don't live in the subsidy world, in general, the rule is something is a subsidy if it's a government benefit, which is normally a grant, a loan, et cetera, that is provided by a government or public body that confers a benefit, meaning it makes you better off than you would have been but for the subsidy. And last, and this is why I'm emphasizing it, is if it is not an export contingent subsidy, it has to be specific to a particular enterprise or industry. Interesting to me on the auto side is to think about whether you're going to revisit the issue because the cars have to be exported. Because in other words, the domestic market in the UK is not big enough. And something, whatever I read the numbers, 62% of all autos produced in the UK are exported to the EU. So if the whole production is really for export, whether you can win on the argument that any subsidy you provide to any auto producer in the UK is de facto export contingent, because the only way it's going to get paid back is if you export the 62% that you have to export because there aren't enough consumers of cars here in the United States. This same
Especially
argument
if the car
was
is
made.
right hand versus left hand.
The same
You sort of
argument-
know where it's headed based on the right hand versus left hand.
well,
Right? No,
yeah.
this is really for the UK market, even though it's on the wrong side of it.
This argument sort of didn't make it in the Airbus case, but it's not clear to me that on better facts you wouldn't win on this being an export contingent subsidy. But anyway.
But what if you don't subsidize the company but the people, like the system of the universal credit that was so much criticized in the
general
EU?
wage subsidy.
So if you subsidize, poor workers,
So
you get-
but that's not industry. So this is the thing. It's not
that would not
contingent
be a
on
specific
ex-
But then it
But
gives a huge advantage to the corporations staying in the UK, because then they can pay wages way lower than any company on the continent, maybe.
Right, but
This is the worker.
But you can't subsidize the entire population. If you
try.
do,
Unless
well,
you're
you could
France.
try.
Unless
You
you're
could
France.
But the rule is
It's
But
not
that's the case now.
sustainable.
But that's
The rule
the
is-
case now.
It
least in
has to
France
be,
you do that,
The
right?
whole
You give-
idea, though, is that it has to be specific in order to be actionable. Because
So-
the presumption is, right, again, and I think it's important to just, one little tiny point. Dumping, this issue of pricing below whatever, is considered, to be condemned in the agreements. Subsidies are not, because the presumption is, subsidies in general, providing roads and schools and water and sewer and lots of other things that governments provide. Yeah, you could call them subsidies, but that is what the governments do, and so we don't consider them actionable, not countervailable. You can't do anything about them unless they are specific, where they're providing a specific advantage to this one person who's now going to be able to compete with me unfairly. So as long as it's a totally general subsidy, it is a subsidy. It makes it very expensive, but it doesn't make it countervailable. So that
It seems like
This is,
Yeah.
well, yeah, I was just going to say, there's a very arbitrary, there's no such thing as a definition of a subsidy versus a tax, right? It's just a negative of a tax, and no body says you can't place income tax on all workers, which is what we have in most countries. So if you want to have as your tax structure, one class of workers will pay tax and another class will not pay tax, and we're going to make the distinction based on high income earning and poor, that's a perfectly legitimate thing, and it's not necessarily impacting international trade. Okay, so
No, you can read all about it in the Communist Manifesto.
Okay.
So it sounds like, though, if the EU is smart, they're basically going to openly say this is what we're going to do, and try to force the United Kingdom to accept free movement of goods, free movement of workers, and then in exchange for that, we'll maintain the common market, right?
I think that would be what I would expect. I mean, it's hard for me to think what they could possibly hope to get out of any type of negotiation, or what the British could hope to get out of any type of negotiation that's not terrible for them. Because I think the Europeans have a very strong hand here. I don't think they have to be open about, like, well, we're gonna attract all your FDI away. I think people will be, that might not make them sound very nice, but I think that they've got to be able to see that will happen. And that would make their populations happy to have those jobs made available to them. So.
Okay, we are out of time. So I want to thank all of you for this incredible discussion. It was really, really rich. I apologize we weren't able to have questions from the general audience, which I know would have good questions, but we just didn't have the time to do that. So thank each of you for this discussion. It's been great, and it should be up on the internet in the next couple of weeks. Thanks very much.